And
They said that this is too bad here. We've got bankruptcy happening. We especially for that, probably will say. That's the challenge. Probably have this challenge. Like, it's right now. Yeah, we've had bad legislative in there. I think the last time.
you know, as folks with those industries, they have trouble winning on good day.
Exactly. Exactly. Oh, dear. She had a little spot for us.
I'm also all on either recognition that she's placed on. So
This guy's the
she may
recipient.
grab
He hasn't otherwise responded. My recommendation
the standard.
You're ready and standing by.
And we still.
What is,
Is your. We're getting close to like the solid foods.
Yeah.
Hopefully I have.
This one,
you need to receive a solid stipend for helping you today.
Yeah, but she knows that she's been reported and advertised.
That's fair. That's fair. That's right. Oh, no, totally. It was never asked to babysit.
they're ready to get called. We can.
They're gonna
we
be
can reach back out.
paramedics anymore.
Just make sure you can try this information.
Like an even a paramedic, depending on the time of day.
I mean, otherwise, I mean, there's no real reason for them. So anyway,
It's a concert on Tuesday.
that's my.
Back, they open at 4 a.m., but
Everybody else out with any of the.
Just. I had it. What is it? They power numbers to 5 p.m. and I'm like.
That's
we
the-
need better.
That's the.
We get through one of the-
I was doing the same thing. I was about to look at this and say, wait a minute. So, you know, as much as you.
Expected my husband. Just keep on driving. Child, but I was like, I just kept driving. I guess we'll see.
Just a tax and.
Well, no, at least
Yeah,
they're.
I was.
They're always.
Sorry. Oh, you think you never. You're.
I might have to go steal that baby and just.
Yeah, yeah.
Yes.
Passing this.
Exactly.
Can ignore her. Well,
Exactly.
If you're gonna show up at one till meeting. That's what I wanted to say to you when you walked in, but you were on the
Yeah,
phone.
yeah, it's just an urgent meeting.
Oh, I.
Ohio Moss, they're gonna have it 10 o'clock. I couldn't, they had a 9:30 meeting for it. I told them I couldn't be there.
Okay. Anyway. To let you get away without hearing something.
I was, the baby don't come up, couldn't take it on the face of the garage.
Service guy.
I know.
You know, when I can have a song play all the way till I'm hurt, I'm like, I don't know what's going on. The guy.
Right.
But it's not an SUV.
You basically need your own parking lot.
Oh, yeah.
Because my cheek is so tall, I'm like, they still, and I don't know. Is that how my son would open it?
I mean, you go. One of the next meetings.
Oh, sure. Yeah, she like. Yes, yeah. Very emphatic about.
So.
So. Sunday. It's like, it's exactly how they're responding.
Fun, but you know, good luck with maturity rate. She's older, but it's like, it's my friend's grandchild. Like he'll just nuzzle up into like, he's just, here's your kisses and. Yeah, exactly. She's pretty, she's. I tried to, she's a lot of.
I said, how could you? How old is she now?
I was like, you put my kid.
Yeah, yeah.
And then.
It's
That should be a lot. Like, yeah, I know.
in the police month.
May as well.
And he's figured out. So when I get home. And so we have to actually lock him. I don't know what I ever have to do with all this stuff. Push up on it.
10:06, and I would like to call the July 20th, 2023 meeting of the Ohio Elections Commission to order. Mr. Richter, will you call the roll?
Mr. Lyle. Here. Ms. Hagan. Mr. Knight. Here. Mr. Pulte. Here. Mr. Carroll. Vice Chair Tavares.
Here.
Chair Kaufman.
Here.
All members are present.
Okay. The first order on the agenda is to approval of the regular meeting minutes from June 22nd, 2023. Okay.
Second.
All right, we have a motion on the floor that's been duly seconded. All in favor signify by saying aye.
Aye.
Opposed, same sign. Motion carries with a vote of 7-0. So we're gonna go
Yep.
to this one.
Yeah, and I would, okay, Madam Chair, members of the commission, unless there is somebody present, I'll reach out here in a second. At least for purposes of argument, I'm going to call case numbers 2023 D005 and 2023 D006 before the commission. Is anyone, aside from Mr. Hartman, is anyone present for either of those cases? Rasmussen versus Pappas or Ranieri versus Tobias? Okay, Madam Chair, members of the commission, these are two disclaimer cases out of the Cincinnati area. Complaints were received, responses were received by some of the respondents in both cases. The reason why I'm calling them together is they're disclaimer cases for essentially the same types of materials, campaign signs for use in a school district on the east side of Cincinnati. I will admit that was the school district I lived in at one point. I was down there. Mr. Hartman doesn't represent necessarily all of the respondents, but he does represent respondents in each case. He not only will be offering arguments from his perspective to argue that the commission should find no violation, but I think he has some other arguments to make. And unless he has a problem with it, I think we'll just argue those together because your arguments, I'm presuming, will be the same essentially for both cases.
Yes,
Okay.
and that's short enough that they can be combined.
And that
The arguments combined.
with nobody else here, I figure it's just easier to go ahead and do it that way. And address both of those matters from your perspective, since that's all we're going to hear. And so if the commission would like to hear from Mr. Hartman on behalf of his clients, the commission can certainly do so. Now, I'm not recommending that we consolidate the cases. So we'll need to take separate action on the two cases. But for argument, we can hear one argument that essentially encompasses both matters.
Very good, thank you. Thank you, Madam Chairman, members of the commission. I think it's very telling that none of the respondents, or correction, none of the complainants are even here today. Because what they are doing in these cases is what was done year in, year out with the false statement cases, harassment for political speech. And it took a federal court to stop this commission from trampling First Amendment rights through the false statement cases. It took the United States Supreme Court to stop this commission when they try to regulate anonymous speech, that being the McIntyre case. And so why are we here today? Somebody put a sign in their yard. That's what the government used. The government are here today. And being used as an instrument, if you will, for political vendettas, political harassment. The complainants truly felt their case had merit. Where are they? They're not here. Because all they want to do is harass, make people engage an attorney, have me come up to Columbus. They're just laughing at back in Cincinnati. You guys don't even give the courtesy to people to appear remotely. I'm gonna tell you, in the second case, there's one person, their daughter put on Facebook that her senior citizen mother, who's a named person in here, is going through medical treatment, is stressed out. Why? Because she put a sign in her yard. And these people want to use you and the heavy hand of the government to force people to come before the government and to say, what did I do wrong? I did nothing wrong. That is an abuse of the Constitution. It's an abuse of the First Amendment. And you guys should not and cannot allow it to continue. It's got to stop. Unless you put your foot down today, it is not going to stop. I want to talk about first the 05 case, Chris. I talk about what's going on. Well, here's a Facebook or a tweet, I believe it's Facebook, because that Ms. Rasmussen put out. There was a dialogue going on about this case. And she, in response to somebody, jokingly makes a comment that I believe it's Mr. Pappas, so mad at me for reporting his rule breaking. Well, first and foremost, he didn't violate them. He didn't violate them. But he said, she gets he's annoyed, he's got to go to a hearing. Gas is expensive. Ha ha, with the smart things. Where's Miss Rasmussen today? She loves to make fun of it. She loves to joke about it. Take a day off, go to Columbus, hire an attorney. Because gas is expensive. And there was no violation of the rules. We did it. I did a memorandum before to the commission. The disclaimer requirement only applies to entities and to a candidate. That is the pure letter of law. In the McIntyre case, it applied to persons. And that's what the US Supreme Court told you was unconstitutional. Yet you allow somebody to file a complaint and then summon somebody. They get the heavy hand of a summons from the government. Not even violating the law. To come in and count. Come on bended knee to the government. I would submit that this shows frivolity in the complaint. Look at 23 revised code 23-2351. It defines, frivolous, not only to have false statements, but it also says definition includes conduct that serves merely to harass or maliciously injure another party or is for an improper purpose. That's frivolous. Ms. Rasmussen has absolutely engaged in frivolous conduct. She doesn't show up today. She makes fun of it on the internet, joking about, you got to go to Columbus and spend gas. Ha ha. And if this commission just turns a blind eye to that, you're inviting this to go on. But I will tell you, unless you put an absolute stop to it today, we will be in federal court. There are other people who simply put a sign in their yard, who engaged in their First Amendment rights to speak, and are now summoned, fear the threat of again being summoned before the government. In terms of the 06 case, I'm here formally on behalf of both Mrs. Perry's, Ms. Ice-Kirkin and Stephen Duffy. But again, all this is, where's Mr. Granieri? No respect for the commission. No concern for the process. So what's he doing? He's made him engage an attorney. They may come up today. Now, trust me, I don't have a problem coming up before you, but what I do have a problem with is this commission enabling the abuse of the First Amendment for simply putting a sign in the yard. Again, this statute does not require individuals to have a disclaimer. Even the opinion available on the website, this commission's from 1996, following the McIntyre decision, clearly indicated it applies to entities such as campaign committees, political action committees, etc. So I would question why we even got summoned here. But even more egregious, I think, from Mr. Granieri's part, is the situation vis-a-vis Ms. Ice-Kirkin. He summoned her, she engaged me, yet she never had a sign in her yard. Never. Yet Mr. Granieri, under oath, attested that she did. You have the affidavit from Ms. Ice-Kirkin. It says it's not my house, it's a house in my neighborhood, Chris. And it was simply and readily available. I'm showing you now pictures from the Hamilton County Auditor's website of the photographs of two houses. He says, oh, I went to the auditor's website. These are the two photographs. On the left is Miss Ice-Kirkin's house. On the right is the house where the picture that he puts in the complaint says, oh, they had a sign in it. I'm going to submit to you, there is no similarity between the two. Either knew or was reckless in terms of submitting a false affidavit under oath, under penalty of perjury to this commission. Yet she's summoned here before the government, and she didn't even engage in her First Amendment right. She actually told me she doesn't do it because she doesn't want to be harassed. Yet you guys are harassing her. Or you're being used to harass her as an instrument. And I pray you do not find that acceptable. I pray you simply do not say no violation, end of case, go and sin no more. We didn't sin. The sin is on the part of Ms. Rasmussen and Mr. Granieri. I mean, look at the pictures. There's an arch entryway on the picture on the right, the house that had the sign. Two distinct windows on the right side of the house. No chimneys in the roof. You compare the two, it's readily apparent. But regardless of that, not only was there no violation of the law, that was so blatant and so vindictive. Do not allow yourself to be used as an instrument of political vendettas and harassment. There is no violation. You need to put a stop to further complaints concerning lack of disclaimers by individuals. I know violation, but I would say send the right message. For two people who didn't have the respect or the decency to even show up today. Find that, yes, these complaints were frivolous and warrant sanctions. Thank you, Madam Chairman, unless there's any questions.
Does any commissioners have a question of Mr. Hartman?
I have one. Mr. Hartman, I'm just curious, in both the affidavits of looking here of Karen and Nettie, they said that they purchased these signs. Do you know who they purchased them from?
It was some local business, saw an capital opportunity, sold the signs. No different than if somebody bought paper and a crayon and drew a sign.
Well,
There was no difference.
other
Who
than,
paid for the sign? The individuals.
I
As far
understand,
as I know. I have no other.
somebody is creating a sign, somebody's getting money for the sign,
Yes,
right? I mean, you'd agree with that?
I'm in a campaign. I don't put the name of my vendor that I bought that makes the signs for me.
No, I'm not suggesting that. I'm just saying that there was some money being exchanged here
But you were,
by the sign
But
maker.
wait.
Is that not correct?
I believe so. I
I
think
mean,
it's.
both of them stated they purchased.
Yeah, okay, you purchased a sign from a vendor,
Right.
no different than buying paper and the crayon to make a sign.
So whoever did that did not put on any.
They didn't pay for it. They sold it. They didn't pay for it. The individuals paid for it. And McIntyre, which US Supreme Court against this commission, said, one, you have a right to anonymous. And that's why the legislature changed the disclaimer law. In McIntyre, the disclaimer law said any person must put a disclaimer. Now that is limited to entities. That is the campaign committees, political action committees, et cetera. And the only individual is the candidate, him or herself. They don't have to put a disclaimer. They bought it, they paid for it. That's the
I
right.
understand that, but it leads me to believe that there was some organized campaign, obviously, against the levy to vote no, which is fine. But just curious about these people receiving funds for creating these signs and then not having disclaimer.
Who should put the disclaimer on when the individual buys the sign from the local business?
I'm not suggesting that the individual should do that.
But then you want to say the business that sold it should put it paid for by ABC company. ABC company didn't pay for it. The individual paid for it. Well, that's the issue. That's consistent with McIntyre. I'm sorry if a business wants to engage in capital sales of business. It's not the role of the government to come in and start regulating that. To say, now we have to be sold by ABC business, because that's what the disclaimer you're saying should go up, sold by ABC company.
No, that's not what I'm suggesting. I'm suggesting that it seems to me that there was an organized opposition. Was it, was it an independent expenditure? I don't know. I mean, we don't have, nobody's here to defend themselves, so I don't know. I'm just,
Nobody's there to prosecute either.
when I understand, but when I'm reading the affidavits, those things come to mind. And I'm just curious about it.
Okay.
So,
That scenario, let me give you a hypothetical. I go to the business and say, hey, we've got this levy on. I think you might be able to make some money selling levy signs, pro or contra. And that businessman makes a business decision. Yeah, maybe I might be able to make some money selling signs, no different than the big sign vendors do. Or you said, what's wrong with a businessman saying, okay, I'm gonna have these signs printed up and I am going to sell them.
but
It's no different than selling crayons or pieces of paper to make a homemade sign.
that's speculation. That's not a fact and evidence.
Well, what's the difference? But you're making speculation about a lot of stuff. There's no
I'm
facts in
asking
it.
questions.
Right, but your scenario,
I haven't reached any decision. I'm asking questions so I can make a decision.
I'm with you there.
Okay.
But is it wrong for it? Are you saying, I'm questioning, you seem to be arguing that it's wrong for a business to sell signs.
That wasn't my question. My question was, do you know who produced the signs?
I did know at one time, I don't know which business sold the signs. It was,
Because I think it's salient, but okay. I hear you. I understand what you're saying. Okay,
I had the same question.
okay,
Yeah, who produced? And I think that's germane to what we're trying to
all right.
kind of figure out today.
but what you're trying to figure out today is disclaimer. Under your rules, and I know you guys kind of pick and choose which rules you wish to follow. You know you do, and you've been criticized for it before, you have, then this whole complaint should be thrown out because it's not double spaced, et cetera. It's not really a proper verification consistent with the section of the revised code cited in your rules. No, you do pick and choose your rules, and that's part of the tyranny of this commission, and it's historic before these current members. It's gone on for years, for decades. But the only issue here is the allegation of a failure to put a disclaimer. But your rules say you've got to identify the provision of the revised code that was violated.
Correct. And that's what I think that's what Commissioner Lyle was trying to figure out today. Is we're just trying to figure out whether it was a entity, like you said, that produced it. But wait, or whether it was just someone who saw a business opportunity. I think that's what we're trying to just decide at this
My
point.
understanding was a business that saw an opportunity.
And I appreciate that response. Thank you.
But all you have before you are individuals who are alleged to have not put a disclaimer on the sign that they posted on their personal property.
Correct. Yes, yes, thank
That's
you.
protected by the First Amendment in this commission, and you should not, you should stop any further complaints against individuals for disclaimer. Because it is not within the law.
Thank you.
There are plenty of people down there in Hamilton County who have signs in their yard that are not yet named. And I'm like, you guys put your foot down. Today. They're going to be there in fear that, okay, well, I've got 2 years statute of limitations before I might be pulled again before the government for engaging in my personal political speech. Gotta stop.
Thank you. Any other questions by commissioners?
Hey, Madam Chair.
Thank you. Hearing no more questions. Mr. Richter, do you have any further comment?
No, my recommendation is to find no violation, in both of these cases. I'll be glad to answer any other questions the committee may have.
Mr. Richter, when was this case set for hearing or preliminary review? I'm
Commissioner for
sorry.
Preliminary review. Let's see, we're in July 20th. The 005 was filed a little bit earlier than 006. Well,
back to 17.
In 005, the notices went out on June 13th. And in 06. That's not, oh, wait a minute, that's not the right date. I'm sorry. For 006, the original notices went out on June 6th. And on 05, the original notices went out on May 3rd. So those were when, it was right around that time when, or the commission received those complaints. Notices were sent out to the respondents.
Mr. Richter, can you go into some detail as to why your recommendation is no violation?
Because the complainant has the obligation to establish that there has been a violation of the statute as it relates to this. Certainly, they brought to our attention that there were signs out there that did not contain a disclaimer, but there is not sufficient, to me, there's not sufficient evidence in that complaint that identifies a responsible party or that points out who is responsible or what organization it came from. It is one of the challenges of the disclaimer law in that individuals are specifically omitted from the statute. And so it can be a challenge for someone to file a complaint related to something like this where there's no disclaimer. And, how do you identify who's responsible for filing a complaint with this commission? And so if you, I don't know what level of effort was put into discovering that by either of the complainants here, but they saw these signs, they indicated these persons. When we get a complaint, if it meets our basic requirements, we're obligated, I believe we're obligated to go forward. So I send out notice and we've gotten responses back from not every respondent, but some respondents that have said, bought the signs, they had no idea, wasn't a part of a committee, wasn't a part of an organization, not my responsibility. And so based on, based on those responses, where I'm coming up with a recommendation to find no violation, and to make it broadly because the complainants have not submitted anything that specifically identifies a responsible group or entity as the statute says.
Okay, thank you. Chair, I have a question. So I agree with everything that's been said, Mr. Richter, but what it does greatly trouble me, the misrepresentation of someone's home. You're going to take the time to take a picture and submit that as evidence. You ought to take the time to verify that you have the right person that you are filing a complaint against. Do we have any options in that regard? I don't know what it would be, but I mean, this is, I do believe it's a pretty egregious thing to do to bug somebody and you can't even figure out which house you're taking a picture of.
Sure. I mean, the commission has an ability to find a matter frivolous. It is something that over the years, the commission has done that. Not often. But from the last time we had a situation where we were finding a matter frivolous, I did research, and I think it was about 6 or 7 times since the commission has become an independent agency where we have done so. We have not done so in a case like this with regard to the circumstance, the specific circumstance about which you're speaking. We did a case that I would highlight wherein we did find the matter frivolous most recently involved a situation where an individual filed a complaint against over 30 persons and couldn't otherwise establish anybody was responsible for that. We have many respondents come in and say, you know, didn't have anything to do with it and found no violation in that case. And so then we went on to find that matter frivolous and went through a process of, you know, establishing what the value was, et cetera, and all those kind of things. It's currently under appeal. I think it's currently at the 10th District Court of Appeals. And so our decision was upheld by the Franklin County Common Police Court, where the decision goes. You know, and so I certainly hear what you're saying as it relates to this. That is something that, you know, presumably it's easy enough to identify and address and certify and clarify what it is, you know, why this was listed. I certainly can't speak to that. I don't know, you know, but you know, the challenge, and I express this regularly when asked about it, about such circumstances. Regularly when someone wants to file a complaint with this commission. Individuals are specifically omitted from the statute based on, as Mr. Hartman has identified, the change in the statute that was a result of the McIntyre decision back in 1995. And it, you know, when you see signed without a disclaimer and you want to do something about it, we are the option that you have to file a complaint. But gotta present something that identifies who could or should be responsible for this. And, you know, so when we get a complaint, circulate it out. In situations like this, it's not out of the ordinary for us to get responses that say, didn't have anything to do with it, don't know. Don't ask me to cite a particular case. I probably should have looked into our prior to disclaimer cases. I didn't do so, I'll be honest with you. But, you know, there have been those times where someone then responds back and says, yeah, we should have done this. We will offer an apology, you know, we make a finding in that particular situation. That certainly hasn't occurred here. You know, so I don't know. This particular case, as it relates to that particular aspect, is different than anything we've ever seen before. And so I understand, I respect Mr. Hartman's arguments. I respect your questions. I don't know that I've got a whole lot more I can add.
You don't believe it, it's the bar for frivolous? That specific one, I'm separating them out.
Yeah, there really isn't anything that's specifically where we've specifically identified, you know, coming to a finding of frivolous, because it would be different with each case and each set of circumstances. And you know, were we to declare that we believe this to be frivolous, then we would have to set another hearing. The parties would be notified that we would be bringing this back. Respondents would be given an opportunity to identify the costs they have had that the commission can impose. The complainant is also completed, or complainants are notified and given an opportunity to present their side of the case as well, as to why we couldn't find it frivolous and impose a sanction. You know, so I mean, there's another step in the process based on the commission's statutory scheme and how we go about identifying whether a matter is frivolous or not, after you hear, excuse me, after you hear all the evidence, then you make that determination of, okay, we believe this matter to be frivolous and identify the costs involved that the commission can impose based on the statutes. It's legal fees, primarily legal fees and commission expenses are those costs that the commission can impose when it comes right down to it.
Thank you, Chris. Thank you.
Madam Chairman, if I can just clarify, I think there is a definition for frivolous that I'd like to put before the commission. It's not defined in the administrative rules that the commission has adopted, but there is a statute 23-2351 of the revised code that deals with frivolous conduct in court proceedings. And I think administrative agencies, when dealing with frivolous things, kind of look to that statute for guidance. And that it actually has an explicit definition for frivolous conduct. Again, 23-2351. There's 4 categories that it says frivolous conduct means either of the following. There's 4. I've already given you one, which is merely serves to harass or is for an improper purpose, which I do think applies to the harassment thing. But 2 other things that they actually define in the statute as frivolous is the conduct consists of allegations or other factual contentions that have no evidentiary support. Specifically so identified or not likely to have evidentiary support. Here, I think the allegations clearly have no evidentiary support. And then the 4th definition is the conduct consists of factual contentions that are not warranted by the evidence. So that's a statutory definition for what frivolous. I think it's enlightening, provides some guidance to the commission as to what is frivolous conduct. And I do think that situation clearly falls within that. Thank you.
What was the third?
It's a nuance between the 3rd one is the conduct consists of allegations or other factual contentions that have no evidentiary support. 4th one says it consists of factual contentions that are not warranted by the evidence. I think both of them are then.
And that is, I think that's the essential statute that we used the last time we did an assessment, but it still comes down to what is established before the commission in terms of the responses that we receive back from the complainant and the other responses from the complainant and the responses, and then you assess that. You have to assess those factors to figure out whether you want to believe it's frivolous or not.
Procedurally in a court, if somebody's making a claim in a court of frivolous conduct, if the court does an initial assessment, does this even rise to the level of being potentially frivolous conduct? If the court says no, it doesn't even fall within those definitions, motion dismissed. If it does, if it says, okay, yeah, I think there was frivolous conduct and I may want to impose sanction, it then has to, actually the law says the courts have to have a hearing, and your rules similarly say there has to be a hearing. Mr. Ranieri is not here today to explain anything. But so I think that hearing is in order for the imposition court to consider whether to impose sanctions. But I think we've presented enough of a factual matter that we do meet the statutory definition for frivolous conduct in a hearing for the imposition of sanctions should be ordered.
Mr. Richter, would that be a separate hearing?
Yes.
Any other questions?
So which case involves the one with the
06.
That's what I'm trying to find too. So 6.
well, regarding
This.
complaint 06, I would like to move that we find no violation and consider the matter frivolous, whatever that in proper wording involves for that decision.
Okay.
Well, yeah, but I don't know what is involved with the motion, the specific
Yeah.
wording.
Right. Okay, so we have we have a motion on the floor to find case number 2023G006. That there is no violation, which is the first step in getting to a frivolous finding, by the way. And then to consider whether the matter is frivolous or not at a subsequent review of the case.
So we have a motion on the floor. Do we have a second?
I'll second. I thought Kristen, I thought it was second.
Oh, I'm sorry.
No.
So we have a motion on the floor that's been duly seconded. Do we need to do a roll call or do we?
That would probably be my
So,
suggestion.
no question, this is just to go to, we're gonna call it frivolous, and then it will go to hearing, is that accurate?
Correct.
To define what there actually is.
Right.
So we have the motion that's been duly seconded. Mr. Richter, will you do a roll call vote, please?
Yes, I will. Mr. Lyle,
No,
Mr. Caraway,
Aye.
Ms. Hoffman, Ms. Hagan.
Aye.
I do know your name, by the way.
Thank you. That's not a big deal.
Mr. Folke,
Compliment.
Mr. Knight,
Aye.
Ms. Tavares,
No.
Ms. Kaufman, Kara Kaufman.
Yes.
That motion passes 5-2. Notice will be sent and you'll be notified when the matter will go back before the commission for 2023-006. We still have 2023-005 to consider.
Okay. So that recommendation is to find no violation.
Got it.
So do we have a motion on the floor regarding case number 2023D-005? Move.
Second.
We have a motion on the floor that's been duly seconded. All in favor signify by saying aye.
Aye.
Opposed, same sign. Motion carries with a vote of 7-0. Thank you very much.
Yes.
Okay. The next case on the agenda is case number 2023G-007. Chris Stanley for State Representative at,
1 second.
sorry.
No, you're fine. Just making those. Madam Chair, members of the commission, this is a self-referral from the Chris Stanley for State Representative Committee. I've circulated to you the materials. Commission, the candidate has found that his campaign committee is out of balance, reflects a negative amount, and he cannot terminate the committee because of zero balance. It's campaign finance filings. My recommendation to the commission, the amount of discrepancy is approximately $390. My recommendation to the commission is find violation and impose a fine of $50 and declare the committee terminated. I'll be glad to answer any other questions that the commission may have.
Questions from commissioners?
Mr. Richter, you talk about a negative balance. Was that a negative bank balance in his campaign account? I know they're the same,
know-
they're different.
Yeah, well, and
Supposed to
the
have-
balance. Well, his phrasing is, we have been able to unable to resolve the discrepancy of approximately $394.06. So what he was reflecting is the balance on hand as last reported is $379 and 3 cents is what it reflects. He's saying a negative balance, he's out of balance at $394. So there's an additional $15 there somehow. Beyond what is reflected in the last campaign finance report and reflected. So, I'm guessing that his campaign account has no money in it and his campaign finance and his campaign finance reports are reflecting, said $379 could be $394 now at this point.
Thank you.
Any other questions? Hearing none, do we have a motion?
So moved.
Second.
We have a motion on the floor that's been duly seconded. All in favor, signify by saying aye.
Aye.
Post same sign. Motion carries with a vote of 7-0. All right, the next case on the agenda is case number 2023G-008, Great House et al. Versus McPherson. McPherson, excuse me.
Fine, Madam Chair, members of the commission, the complainant asserts, the complainants, there are two, asserts that the respondent failed to file various campaign finance reports or reflect any expenditures. There was no written response submitted to the commission. And so with that set of circumstances, my recommendation is to set the matter for hearing. Based on the sign-in sheet, the complainants, Mr. Greathouse and Mr. Brown are present, and the respondent, Mr. McPherson, is present. If the commission would like to hear more from either of them, they could come to the floor, be sworn, and make additional statements to the commission.
Mr. Greathouse just stepped out for 1 second and will be back, but he's more versed in this. If you give him a second, to straight back, it'd be him now.
Indeed it is.
Yes.
So we would, Jim, so you come forward.
The complainant should be at the table on the right, Mr. McPherson, at the table on the left.
Yeah, well, you first. Sure. Buddy.
Mr. Greathouse, did you want to have anything additional to say to the commission?
No, I think my complaint letter speaks for itself. We just asked that our fellow council person follow the same rules that we all had to as far as reporting campaign expenditures, and that's all we're here for.
Well, that was a statement. Why
Yeah.
don't you stand up and just want to make a statement?
I apologize.
Yeah, thank you.
Raise your right hand to be sworn.
Sure,
You swear the testimony you'll give in this proceeding will be the truth, the whole truth, and nothing but the truth to help you God.
I do. All right. I need to repeat.
Yes, please.
I'm here today. My original complaint, I think, speaks for itself. We're just asking, myself and Mr. Brown are asking that our fellow council person report his campaign expenditures, just like the rest of us have been required in our own. Thank you.
There could be, are there any questions from commission members?
Thank you.
You're welcome.
Mr. McPherson, if you would like to address the commission, please stand and be sworn.
Raise your right hand. You swear the testimony you'll give in this proceeding will be the truth, the whole truth, and nothing but the truth to help you God.
Oh my gosh. I thank you. Can you hear me okay? I think this case is about harassment. It's about, political vendettas, political harassment, and not reckoning. I would like to ask that the commission, that this is a motion to dismiss the matter. Because there's no violations made knowingly or purposely. The complainants truly believe violations were made. Why did they file a complaint against my opponent who they supported, who failed to file paperwork and actually admitted in the same article that he accepted money from a PO box. That's why he didn't get his expense filings filed on it. My filing was on time. My preliminary report was, both my reports were. There are a number of missing items in that pre-election reports. The complainants did not attempt to address this either in their media where they went to and danced around on this prior to the election, nor with this commission. I think that illustrates the bias of the complainants and their politically motivated reasons for filing. I think another thing that complainants are upset about with me personally is over their previously failed attempts to have me removed or punished from city council. They tried to have a meeting, conduct an illegal meeting where they tried to go into privacy and violated the Ohio Open Meetings Act, or Sunshine Act, ORC 121.22. They had a citizen leave, they had me leave, they voted illegally during a secret meeting. Clear all just violation after violation of ORC 121.22. In fact, so flagrant that the citizen that was asked to leave filed against them, and they were found guilty of holding a secret meeting and having votes during that meeting they should not be having. So this is clearly established case of, political retribution and, blood raking at a local level. I think that, the reason I didn't file any paperwork and, this lawyer that was here is $500 an hour. Election lawyers, he talked about it. This is, spending time and money and effort and figuring out, reading web pages, going through everything. I'm coming here to tell you, we filed an addendum. My, deputy, treasurer and I went through everything and said, okay, let's just add everything. So we, prior to the deadline of the final filing, threw everything I could possibly think of and added it in. So if you look at the filings, we're fully filed. We think we were fully filed and compliant all the way through. But the addendums filed with the Ohio Elections Commission, or whoever we file this with, we file with the local Board of Elections. But I believe you folks can see those publicly available. They're public records. So if you go look at that, that's all been done in a timely fashion, and it's I think more than answers any of the spurious complaints they made in their arguments. To give an example, they cited in some of their evidence a newspaper article making some claim about me. Well, in June 19th of 23, after the post filing, the paper published an article saying that I had expenditures, and donations and such, which I didn't. I self-funded everything out of my own pocket. I didn't want to have any. I'm all about open meetings. We're constantly complaining about that with Liberty Council and some of the things we do. It is something I'm very strong about. I have nothing to hide from anyone in terms of how I spend my money in any way. I think that when your website says when trying to see if a report, is pertinent statements. I think this statement is my statement. I didn't file any written affidavit, but I think this counts as I had no intent whatsoever to hide anything. I didn't take any checks from anybody or any money from anybody, so I didn't have to file any receipts of money I spent. Everything I spent is spent out of my own personal expenditures, my own personal accounts. I think that when we did file the first filing in January, my deputy treasurer had done a FedEx, and we included that on that. And so we did have items that we'd spent that we felt that were reportable. Subsequent to that, we amended and just added everything, threw everything on, stuff we didn't feel that was required to be reported. And beyond what I think what's required. And I'm totally open in regard to that. So if there is anything, any mistake or faux pas I might have made, I believe that it wasn't done knowingly or purposely. I don't think that it was flagrant enough to have to come down and spend a day down here doing all this. Any more than if they really believed it was, why did they file against their friend, the mayor, who openly admitted in the same article they cite that he didn't file his expenses in his pre-form because he had taken money inappropriately. And so I guess that goes to the point of I don't think this is supposed to be about nitpicking and political vendettas. This should be about, in my opinion, about somebody who's legitimately out to circumvent things. And I have nothing to hide. So I open any questions you have for me regarding this case.
Thank you.
Thank you, Chair Coughlin. Thank you for your time and testimony today. The only question, you made a statement that you reported what you felt was appropriate to report or not report. As if there was discretion on anything that was expensed for a campaign to be reported in full. So could you provide more clarity?
Yeah, I don't know. the deputy treasurer's CPA, right? And maybe comes from the private side and that he's, used to doing auditing and stuff like that. And his read of it was that we didn't have to file that. I'm like, all right, whatever it is, right? And certain items, and I'm like, okay, if that's your read on it, good. And I trust that you have that correct. And then after these came up, I said, why don't we just, even if that's still your read, let's disclose anyway. Let's put it in the final report, put it in an addendum, and then amend the previous. So we amended it immediately, just to come forth with, instead of coming in here and arguing why it would be or not be, right? And I don't think it's discretionary, but I just think it's an accountant who is steep in the way he reads things, having his opinion of how things are, and then, in my opinion, rather than argue that out, hey, let's throw it all on, put it all in there. So that's, if you look at the addendums, it's all there, every bit of it that we talked about and more.
Madam Chair, I have a question of the respondent. You're up to date on all reports you're asserting today, so there are no outstanding issues for any of the reports that you've submitted to date?
No, none. And all the allegations they made, all of those items are covered and more. The only thing we haven't filed yet is to close the committee. I closed the account, and we're waiting for the result of this hearing to figure out if I gotta keep that account open or not.
Can I ask Mr. Richter? Mr. Richter, is that your understanding from the Board of Elections?
I have not had conversation with the Board of Elections, so I don't know the answer to that.
Thank you.
I think I have more of a comment than a question, but maybe it is a question. And I think it goes back to what Commissioner Hagan was asking, because you've said a couple of times it wasn't flagrant enough to warrant, having anybody look deeper into it. But I guess that in and of itself is it flagrant? Were there things that were not done? And so it was flagrant, but it wasn't flagrant enough to warrant being called to, to come before us. So I guess what's that definition? What does that mean? I don't understand that statement, I guess.
Yeah, I guess that goes. Yeah, you guys are adjudicating Claudia on that, right? I get that. What I'm trying to say is, if this wasn't politically motivated, right? They would have filed against my opponent, their friend, the mayor, right? Because he had items on there, right? Receiving money from a PO box is clearly a violation. There's no, he admits in the paper saying that I failed to file on a timely basis because I accepted money from a PO box. I'm not saying that, right? I'm saying that my expert that I said, yeah, we don't want to do that. I said, well, we're going to do it anyway. So let's get it done. Because I don't want to come in here and argue minutiae of accounting rules and ORC this and that and all these details, right? And I said, let's just file it, put it in there, and put it all, every little thing I spent money on, everything. I went through everything I could possibly track down and put every line item detail down to miscellaneous $10 here and $5 there.
Okay.
So, and because they may be considered personal expenses, some of them, right? And that was the category, right? That he was relying on. But from my point of view, I have nothing to hide. I'm proud of the work I put in to run. I'm proud of being very open and transparent with everybody at all times and any time like that. And I hold myself accountable for that. And I hope the commission looks at that aspect of knowingly or purposely, the fact that I wasn't trying to hide anything. There's nothing really to hide, right? And that there was no intent to violate anything whatsoever. That, I think that's what I was trying to say.
Thank you. Thanks for clarifying that.
I have questions. Nobody else.
Anyone else on the commission? Mr. Richter has some questions.
How familiar are you with the campaign finance reports that were filed on your behalf? Have you reviewed them or, did you look at them? Did you see, you talked about talking with your treasurer,
Yeah,
et cetera.
right.
Well, when I look at, I'm looking at what, was downloadable from Trumbull County Board of Elections.
Right.
And it shows an original submission date of January 26th, timely filing an annual 22 annual report. It shows no activity. Then when I look at the pre-primary cover sheet, at least, which was filed April 18th, it shows a beginning balance of $30, and an ending balance of $30. What's the difference? How, are you aware,
To open a checking account, right, you have to have $30, right? So I opened a checking account to have a checking account, but I never used the campaign checking account whatsoever. So that $30 was a deposit for me into that account.
okay, but, and when was that made?
When I opened the account, sometime after the certification of the election.
Presumably sometime in 2022? It's
No, this year, March of 23.
Okay. Have you had any conversations with staff at the Board of Elections as it relates to their acceptance of your campaign finance reports?
Yeah, and they said they got them, and I said, are they in order? Do they look like they're there? They said yes.
Good.
And I said, and at the time, there wasn't, actually, I haven't talked to them since this was filed. So I haven't talked to them since this case was filed. So I talked to them prior to the filing of this. They got the addendums. We chatted, they said they were all there, and I'm like, okay, good. And then I get the letter in the mail a few days later.
When you got a letter from us?
Yeah, right.
Okay. All right, yeah, I mean, I see that an amendment was filed for it reflects it for the primary. And it shows, almost $22,000, 21,600 in expenditures. You had all those expenses yourself and you just reflecting them as in-kind contributions. You made all the expenditures. You didn't receive any other contributions.
I didn't receive any contributions whatsoever. And that's what the article on June 19th indicated, that I had gotten some kind of contributions from some realty company or some real estate guy or something. And I'm like, oh man, I self-funded, I'm blessed beyond what I deserve, and I have plenty of money to run a campaign. Didn't want to take any donations because it shows strings attached, right? And so I ran this all out of my personal savings.
Thank you.
Any other questions?
Madam Chair, if I may, so when you wrote expenditures,
Right.
campaign related expenditures, you're saying that you used a personal check
Correct.
rather than your campaign account.
Right.
May I ask why you didn't give your campaign committee money from your personal account and reflect it as either a contribution or a loan?
Yeah, because it's all my money anyway, and it's personal expenditure, right? And run this as me, as Ken McPherson is running for office as an individual. And I think there were folks who expressed interest to want to donate money. That's why I created the campaign, but then that account to maybe take it. And then after I got into it, I'm like, no, I'm doing this for me. I'm doing it on me. I'm spending my money, and I didn't take any donations at all. And so And I never had intent to like, then that's extra work and move that money in there, you know, then write it out of that checking account, you know, you only get so many checks out of those corporate accounts, right? And then sometimes buying stuff with credit cards, right? You know, they're like big checks, right? You can't get a credit card on that. These are funky little accounts you set up, right? They're temporary banks, nonprofits and paying things that they're created, the little banks, some banks will be created. And so the credit union does, so I gotta create a credit union. And for me, it was a matter of a personal issue of saying like, this is a campaign. It's my money. I was very distinct about not taking that, being independent. And I wanted to make sure all those expenditures were from me. So I didn't let even any in-kind. Everything I spent was paid for by me. Everything I got paid for personally by me.
Mr. Richter, were the reports filed timely?
It appears that they were, the original submission date reflects as it being timely. Yes. But then there were subsequently, looks like amendments were filed on June 9th. Not only, well, along with post-election report being filed on June 9th, an amendment was filed that reflects a variety of activities, none of which really matches up with the cover pages that are included with the reports.
Yeah, because you're saying that the cover page doesn't, it's the original still, and the addendum doesn't line up to that original.
Correct.
Yeah, that's, I did bring that up with the Board of Elections. They said it takes time to synchronize. That cover page, getting it correct to match the detail. I'm like, all right, well, I filed it. And when I go in through the portal to look at it, it's all there, right? You see them there when I click on them. But I indicated to them, they're like, well, take a day or two for it to update. So I don't know if that's something that you're indicating is still from the access point you have that's wrong. I could email my copies that I have from that portal, but if the portal's wrong, but that cover sheet just doesn't update the new version. It's keeping the original there. You know, because the way that locks down, the way that UI works and the user interface on that late drop down, it's showing the original cover sheet and not the updated one we put in. You know what I mean?
Okay.
Any other questions?
Mr. Richard, do you have a recommendation?
Yeah,
Excuse me, sir, before, I would like to speak prior to the. Before you make a recommendation.
okay.
And one last thing, and part of this is that, this is nerve wracking, right? Hundreds of dollars per day in fines, right? You know, these guys going in the media and crowing about, you know, what a guy, I can't keep track of do my paperwork right and all this and then criminal, right? One of the things you could do is send this off to a prosecutor to have him prosecuted, right? So my blood pressure's pretty high right now. The stress level's very high. And so that takes into effect like spending time on this. And you know, it's probably why they filed this, why, you know, they make everything more problematic. And when we do business, to try to do the people's business, everything's a fight and acrimony. You know, he's yelled at me in council at times, John Brown has, interrupting me while I have the floor multiple times, trying to keep me from doing the people's business. That's what led to the frivolous case where they tried to kick me off council illegally and had the illegal meeting they got in trouble for. And that goes right to the point of, you know, this is a lot to go through to just put yourself up to run and then, you know, drop tens of thousands of dollars to run out of your own pocket and then have to then face criminal proceedings potentially. And I think I'm far from that, I hope, but that's still in the realm of some possibility, hopefully 0%, but you had a question?
No, just listen.
So I just wanted to convey that, right? But that is that's part of the nature of this, and I understand it's your job to overlook that, but I appreciate you take that into consideration too, but. You know, and then it's difficult to see like how to file stuff with this. I was looking at the site, and it's a lot of anxiety and turmoil. I'm sorry for not getting into copies of those because I figured they were publicly available. Now here it turns out that they're wrong. So,
Thank you.
thank you.
Yeah, thank you for your statement.
My name is John Brown.
He's sworn.
Richard, you swear the testimony you'll give in this proceeding will be the truth, the whole truth, and nothing but the truth to help you God?
I do. Thank you. Mr. Richter, I was glad to hear originally that you said that you thought this should be set for a hearing, and I was not originally going to speak. I signed up. I thought Mr. Greathouse could speak, but hearing the gross prevarications of Mr. McPherson, I feel that I should, and I'm glad that we both traveled down here. It didn't do me, any joy to get up at 5 a.m. and travel from Warren, Ohio down to here. It certainly is not a vendetta. I was not part of, I have never gone to the press about this. I'm council president, so where he's talking about things, I don't even, those things are separate from this, but I just hope that you will set this for hearing because, I've been a councilman, a council at large and council president. Mr. McPherson's been a councilman, a council at large, and we do those same filings, whether you're a councilman or a council at large or running for mayor or running for Congress or whatever. You have to file them, you have to do it in a timely manner, and you have to show people, this is a city, we have a city of roughly, we're down to a little under 40,000 people now, but it's not something that we could frivolously do, and it's something that Mr. McPherson's understood from other times. I don't take any joy in filing this against him, and I hope though that there's a lot here that's been said that is not true, and I would just hope that it would go for a further hearing.
Any commissioners have any questions for Mr. Brown? Thank you.
Can I speak to that? What is some of the things said?
Briefly.
Two things is he used the word prevarication. That's a fancy polysyllabic word for lying. Nowhere in his statement did he make any claims that I've lied. So despite that, I didn't lie anytime to you or at any of this point, and he made nothing to substantiate that. Number two, I've never filed a report. I've never been having to file a report. So our county people tell me that, and I think the same for them, if you're less than a certain amount of money spending in a council race and a local race out of our county board of elections, you don't have to file. And so there's no paper filing there to file. So this is the first time I've had opportunity to spend this kind of money, which there is an exception for the amount you spend, right? That there's, if you spend less than a certain amount of money, you don't have to file. So this is my first time to file. So for him to state that I filed before, I've worked with Joanne Volchek down at the Trumbull County Board of Elections. And every time I ran, I never spent more than, I think she said the number, the criteria was $1,000. So I didn't have to file it in the paperwork. So I wanted to address that clearly. This is the first time I've ever had to file. And that may go into your decision-making also, please.
Thank you.
Mr. Richter, could you speak to that, on the requirement to file?
Yeah, well, it depends. I mean, it's whether you have to file a pre-election report or not is whether you have to go over $1,000 in contributions or expenditures. You're always required to file a post-election report, regardless of the amount that may be out there.
Okay.
So, that's what plays into that scenario. Let's put it that way.
So any further questions, comments? Mr. Richter, you said you had a recommendation.
Yeah, I'm changing my recommendation. I mean, certainly if the commission decides it wants to have a hearing here, certainly capable of making that decision. My recommendation, I'm gonna change my recommendation after hearing the statements. Mr. McPherson, looking at the campaign finance reports. I'm gonna recommend that we find that there was violation of statute as alleged. But I'm gonna recommend that the commission find good cause present not to impose a fine. Based on the fact that he made the trip down here, made the statement to the commission, and reports have been filed. The reason why I'm recommending finding violation is when you look at the annual report that reflects all zeros that was filed on January 26, 2023. It's all fine and well and good, but that presumably was what was submitted in January. And when you look at the amendment that is submitted, reflected as being submitted on June 9th, 2, 4, 7, it shows somewhere around $10,000 of expenditures in 2022 from October through November of 2022, made by Mr. McPherson. Then when you look at the pre-primary report that reflects $30 as from the last report, which is kind of already, as I've already identified, wasn't reflected as the ending balance of the annual report, but is reflected as a beginning balance. But it should have been a zero beginning balance if he made the contribution to the committee and or a contribution to the bank account in 2023, as he says. But then it reflects, you know, substantial contributions, about $20,000 in contributions in the period of time, the pre-period of time. Then you look at the, oh no, I'm sorry. Let me change that a little bit. Yeah, no, that's the pre-period, that's the pre-primary filing, then the post-primary filing, which was reflected as being made on June 9th. Also, the cover page shows $30 beginning balance, $30 ending balance. But then it reflects the $21,000 in in-kind contributions in there. The numbers don't necessarily, I think, in what is reflected as the original reports don't properly reflect the nature of the activity during the period of time when the report could have reflected all of those expenditures, in my opinion. So that's my recommendation to the commission.
Madam Chair, just a question of clarification to Mr. Richter. We've had no conversation with the Board of Elections, is that correct?
Correct.
Okay.
So can you restate your recommendation?
To find out that there is a violation of the statute as alleged in the complaint, but for good cause not imposed a fine or for a matter for prosecution.
So moved.
Second.
We have a motion that's been duly seconded. All in favor signify by saying aye.
Aye.
Opposed, same sign. Motion carries with a vote of 7-0. So at this time, thank you for coming up.
You gentlemen should stay there.
Yeah, you can, yeah. Thank you.
The next case, Madam Chair, members of the commission, is case number 2023 G009. Same complainants against the Warren Deserves Better et al. A series of respondents. We received a number of responses. I circulated them all to you. This all relates to a charter amendment issue that was on the May ballot. There are a variety of allegations from failing to establish themselves in the PAC, failing to put a disclaimer on campaign materials. Be the case. Something on the right there. And various other campaign finance filing issues. And so I'm at this point, my recommendation is to set the matter for hearing. So there are no disclaimer allegations. I apologize for that. But there are various campaign finance filing allegations for failure to establish a committee. You've seen all the responses. Ms. Milner is here. Mr. Perini is here. Ms. Milner's response included a response from the person that set up the organization for them, certain that they were I guess you'd say a nonprofit organization of some sort, which is all fine and well and good. But I'm believing that some of the activities that they undertook would establish themselves as PAC because of the materials that were included, not only with the complaint, but also with their responses does reflect express advocacy on behalf of the issue that was on the ballot. So anyway, the commission can hear from the parties if it's, excuse me, if the commission chooses to do that. Mr. Greathouse, would you like to address the commission?
I would.
Just to remind you, you've been sworn, and so.
Sure. I'll make this brief, everybody. The reason why we're here is the same reason that we were here before. I felt by reading the campaign finance handbook that a PAC needed to be established and contributions and expenditures needed to be tracked and reported in compliance with state law. I didn't think that this entity followed the state law, and I didn't think that was right, and that's the reason why I filed the complaint. And that's the only remedy that we're asking for, is that that entity disclose, where did you get your money? What did you spend it on? And what's left over? Those questions to this day, I think, remain unanswered. And I would ask that this commission dig deeply enough into it to find the answers to that. That's the reason why I'm here today. Any questions for me? I'm sorry, that's your job.
Good job. You made the seat. Thank you.
Round, you do say anything, just be better.
Okay, so no statements. Okay, thank you.
Understand, please. Thanks.
Thank you. All right, sister. You sworn.
Sure. Sir, that's what you're giving this, it won't be the truth. Nothing but the truth to help you out. Yes.
Thank you.
Good morning. My name is, of course, Tina Milner, but this was not a political action committee and this was not a nonprofit. This was a civic engagement. There were a group of residents who decided that we wanted to move the discussion of shall a charter commission be formed to frame the charter for the city of Warren, which is operating as a statutory, and is only one of 6 cities left in the city and the state of Ohio that still operates as statutory. We conducted this group as for educational reasons only. We started out with teaching people how to run for precinct committee seats with information. If they wanted to run for city council, they wanted to run for, the one lady wanted to run for county commissioner. It was an educational group meeting that was open to the public, that it was bipartisan, and the whole premise was to educate our residents. Our residents have a tendency to believe everything they're told by an elected official, whether it's truth or error. We also established a website with Q&A for people to understand what is a charter, what is a precinct committee person, what the requirements are, strictly for educational reasons. Once I decided that I wanted to move forward with a charter initiative, I asked for volunteers. These people were volunteers that decided that, yes, it is time to bring Warren into the 21st century. And so we moved forward with trying to establish, to get the issue of shall a commission be formed to frame a charter put on the ballot. Now, this is something that's been discussed literally for 20 years in Warren. Should we move to a charter, not move to a charter? But it was always done by the city council members. As a matter of fact, Mr. Brown actually proposed charter government prior to our initiative. So it was always done by city council. It was always voted down, or our residents were always told now is not the time, which is what our current mayor likes to say. Now's not the time. So we just moved forward. I asked for volunteers, the volunteers came forward. We picked up this buzz phrase of Warren deserves better, actually from Mr. McPherson, because he kept saying, don't you think you, as residents, we deserve better? And I thought, yeah, Warren does deserve better. So in order to establish a website and informational materials, we adopted that buzz phrase of Warren deserves better. The website and the educational materials, the Q&A, the precinct meetings, the civic engagement was done prior to before we even collected signatures for the charter initiative. The only reason that I established a bank account was because I had people that approached me that wanted to donate money to offset the cost. This is Mr. Perron, and Mr. Perron was one of our charter commission members, as well as our charter committee member. And we all discussed each person individually going out and paying for their own t-shirts, their own materials. But if anyone wanted to, that was not a part of the committee, of the group, wanted to donate money, I set up a bank account because I wanted to be fiscally responsible for the money that was given to me. And that is the reason why the bank account was established, because I didn't want to take money from people and then not know where it, that it write checks to me personally. I didn't want that responsibility. So I set up a bank account under Warren Deserves Better. We have never operated like a political action committee. We have been a group of citizens doing civic engagement to educate our residents. Unfortunately, our residents do not take the time to research information. So they're going to believe anything they're told, even when Councilman Greathouse told them, if you vote for a charter, government ends immediately, which isn't true. So that was the premise of this organization. And this organization is, the Warren Deserves Better meetings. And those meetings are still going on because we're still going to educate people about government and about civic engagement. Whether it's establishing a neighborhood group, whether it's how to report issues to your council or to city departments. And that is, the bank account is still open. It's like $4.59, but it's still open. So this is not a political action committee. Anyone have any questions?
Thank you. Would you like to give a statement?
Oh, I do have one last comment I want to make. I do believe what is going on is slap litigation with our city council members. As you can see, it's pattern. It's filing here, filing here, filing here against anyone that speaks out. All of the statements that you got from the people that were actually part of the committee stated they had spoken out or had issues with an elected official. And we really believe it is strategic lawsuits for anyone that's a public participation.
Thank you. Mr. Blanch.
For the testimony you're giving this proceeding, the truth, the whole truth, and nothing but the truth, so help you God.
Yes.
Thank you, Madam Chair. Thank you for the opportunity to present my case before this committee. I was one of the 6 members that was on the original petition to see if we could place a charter government on the ballot in the May primary. And there had been several issues with council of Warren that continued to delay since we did have enough signatures to put this on the ballot. It went to a 3rd reading before it was finally stamped and approved. But prior to the 2nd reading, Mr. President of Council harassed me personally about you have no idea what you're doing and that your initiative, what you're doing, is totally out of place. And so it was more fear mongering, not only with the members that were part of this initiative, bring a charter government for Warren City, but also the residents, because there were consistent mistruths that were being said about what a charter government is all about. So that's why I'm here today, to defend our case about, just educating people in our community, the benefits of what a charter government can do. And not have a fear mongering city council that continues to badger the citizens and the initiative people that continue to try to make our city better. Thank you.
Any questions for Mr.
Questions?
before he steps down? Thank you.
I guess I would like to here now, quickly. Yes, I am still under oath.
Correct.
Just to in response to that, I did speak with Mr. Bryan, who I've known for a long time, who were kind of friendly. And my statement to him wasn't that he didn't know what he was, that he didn't understand the group that he was getting into. And their names are atop this petition. And that I wasn't trying to intimidate him. I was trying to speak to him as a citizen that I've known for a long time, but I wasn't saying that he wasn't doing right. I don't want to muddy up because that case is gone, but I guess.
Yeah, we won't address what we've already decided.
Well, okay, I mean, just anyways, that I told him, you don't understand the group that you're getting yourself involved in, and he's a good person. And that was the point of my talk with him. Thank you.
Okay, thank you.
I didn't sign up, but I didn't know, am I allowed to speak if I would have?
He's not a party. to
No,
that.
not-
You gotta be a part
No,
of it.
thank you then.
But I want to speak on that part.
Yeah. So what questions do we have from the commissioners?
So, Mr. Richter, your recommendation is to set the matter for hearing.
Correct.
Is it necessary to set a full hearing when we have, we've had both parties here? I take a look at the postcard. There's very clearly advocacy, a vote
Mhm.
yes.
Yeah.
So my question is it possible for us just to find a violation and to impose a fine, or would you rather do a hearing?
Well, no report has been filed.
Okay.
I mean, I ran just the name Warren into the search function, that is available at the Trumbull County. It's available in all counties now at this point. The Secretary of State's office houses it. And nothing came up for Warren deserves better. I mean, I appreciate Miller's argument, the approach that they've taken. And I'm certainly not against them trying to get a charter approved or all those kind of things. But, if they had just taken the same materials and said, here are all the good things that we get from the charter, I think her arguments as it relates to them not being a PAC would be reasonable. It could be a PAC still, but it would be reasonable. Alternatively, when you advocate for a particular issue, as was done in the materials here, that changes the nature of what you are as an organization. And so, like I said, I'm leery of, we could find a violation and then, and impose it pretty fine, until such time as the reports are filed. Until such time as they establish, they could challenge that decision presumably, or we could set the matter for hearing. Maybe in the interim, they take care of what I believe are their responsibilities. Or, we have the hearing and then they produce sufficient evidence that establishes that what they did was satisfactory and sufficient. And the commission makes the finding that it does based on that evidence. I'm sticking with my recommendation to set the matter for hearing. But I'm babbling on. That's kind of where I'm coming from. I'll be glad to answer your other questions that you all may have.
I have a question. To set the matter for hearing. And they don't agree that they're a PAC, but we believe that they are based on the advocacy. We're still at the same point of no reports, right? Not really advanced anything to having a hearing.
That there is truth to that, correct?
So, if I guess to me, it's a different next step based on, do they now, based on the statutes, believe they're a PAC and need to do the things that a PAC would do reporting wise? Or if they don't, I think the next step is different? Because if the next step is that they would agree that there's a PAC, we should let them have a chance to file the reports and address the matter at that point. Unless I'm missing something.
No, that's certainly a reasonable approach, yes. That's certainly, or at least not an unreasonable approach.
And I guess, Mr. Richter, you know, the clarity for, my colleague and I, as we were discussing, here in the committee meeting, is the vote for. If it had said vote for, vote against, that it should be considered a PAC.
Yeah, I mean, over the years, we've seen a variety of materials that have been, probably more in false statement cases, which, dealing with anymore, where allegations are made, but it's, either something on behalf of the school district or against the school district, where, all they do is point out how great their school district is, or, how great their city is, and et cetera, et cetera. And they make a lot of points, but they don't specifically advocate for or against an issue. And so therefore, there's no need for them to be a PAC at that point, because they're not, they don't fit the definition of a PAC. They're not two or more persons, the primary or major purpose of which is, through express advocacy, supporting or opposing an issue. Here, we've all seen and looked at these materials that, yes, I see. I think, well, I pointed it out to you and vote yes to charter government, vote yes to charter on May 2nd, vote yes for charter. There's, there's express advocacy there that changes the nature of what they're doing, what they're trying to do, and creating themselves as a PAC because they are expressly advocating on behalf of an issue.
Ms. Milner would like to address.
Okay, if you're so, okay.
You're saying that there was advocacy for voting yes for the charter. In the packet, I had submitted flyers that were handed out by volunteers for the current mayor, where he's saying vote no for charter. And then there was also letters that were written by the law director, as well as city council members telling residents to vote no for the charter. So would that qualify them as an individual, as a PAC? Because as an individual, I am the one who spearheaded this entire initiative and only asked for volunteers. There was only the committee that oversaw the petition process to collect the signatures. Other than that, it dissolved. There was no committee. There was no group. It was just a group of volunteers who wanted to get the message out about charter government. The materials, the mailings, all of that was done by me, not by a group. So if they're allowed, if the opposition is allowed, different city council members, as well as the mayor and the law director are allowed, and the city auditor are allowed to mail out materials telling people to vote no, then does that qualify them as a PAC as well?
Chair. Maybe, but we have this complaint, so that would be a separate issue.
Or a separate filing, a complaint?
Correct.
Wait, hold on. Any questions on Ms. Milner as she's up there? Any further questions?
Ms. Milner, in this situation, I thought you said that you collected donations, is that correct?
I did. When people asked, they said, well, what can we do to help you? I said, I have an industrial size copier that can make anywhere from 3,000 to 6,000 copies, depending on the type of copies I make. But toner's not cheap. So those were the kind of things that people wanted to donate towards, was to help get educational materials. And also
What's your guesstimate as to how many dollars you collected?
I can tell you, I know, $1,400. 200 of that was mine, 200 of that was my brother's, and the other was $1,000 from one individual. So, 200, yeah. 200 was mine, 200 was my brother, 200 was another person, and then 1,000 was from one individual. There were people that offered in-kind services that would go out, make copies, do things like that. But the volunteers themselves knew that they had to put some skin in the game. So what they did on their own, and they covered it themselves. And if you look at our website, orangedeservesbetter.org, there is a Q&A on there. What is statutory? What is charter? It lists different things about the comparison between charter and statutory for educational purposes. Okay.
But ma'am, there's also vote yes. On
Okay,
your
great.
website, yeah.
But there is a
So
Q&A
that's
on there. Okay,
I
but
think that's the problem.
there is a Q&A. There's an informational material that was put on that website. I feel like voting yes on that website that I maintained is my First Amendment right. I just used a buzz phrase. Warren deserves better. We do. We deserve better than what we have.
Thank you.
And this is obviously SLAPP. This is strategic lawsuit, political participation. Thank you.
What? Does anyone else have a question for Ms. Milner?
I do not. Madam Chair, I move the executive director's recommendation to set the matter for a hearing.
Here's a motion. We have a motion that has been duly seconded. Let me do a roll call, or did you just?
Well, we,
Yeah, okay. So, Mr. Richter, will you please take the vote by roll?
Mr. Knight,
No,
Mr. Caraway,
No,
Mr. Lyle,
Yes.
Ms. Tavares,
No,
Mr. Kolke,
Yes.
Ms. Hagan,
Aye.
Chair Kaufman.
No.
That matter fails 3-4. This is there any other finding or matter that the commission wants to pick up?
what would be the option of, I guess, I mean, in layman's terms, what I would propose is, the executive director have a conversation with the respondents after, and based on that, have a recommendation on how to move forward at the next commission meeting.
I wouldn't suggest it be at the next commission meeting.
Well, whatever date.
We continue consideration of preliminary review.
That's what I would
I
recommend.
mean, that's probably, based on what you just said, that's probably the appropriate thing to do.
and you could work with them, Mr. Richter, to make sure they are brought into compliance.
I will have, I can have conversations with them as appropriate. And that's what they do is up to them, obviously. But, we can continue the preliminary review, bring it back at a later date, probably sometime in September.
And that could be done by the chair, correct? Or does that require at this point a vote?
Do you mind projecting one more? She is hearing me.
Oh, I'm sorry. Yeah, the chair could continue it. Yes, I mean, we've normally done that on matters, just have the chair continue it if that's what she wishes to do. Or if you wanted, we've had it's rare, but we've had motions before to continue matters, so that's always a possibility as well.
No clarification, we're continuing it, why, or for what?
Louder,
So,
please.
I want to know why we're continuing.
To allow for conversation between myself and the respondents as it relates to, I guess I'd say, the commission's approach toward this matter, and the commission's belief of, the nature of the organization.
Okay, so.
All right.
So my question is to Mr. Richter. We could find, based on what we've heard today, we could have a finding that, and I'm just putting this out there. I'm not saying this is what we're finding, but we could say we find that as a PAC. And that they would need to file the reports, the, campaign finance reports, all of their information need to be filed. We could find a violation, impose a fine, but to be reconsidered upon those reports being filed.
That is certainly another possibility that the commission could undertake. Yes.
And then that way, maybe,
Yeah, Madam Chair, I agree with that. I brought it up initially.
Yes.
To save, matter for a full hearing, was to go ahead and find a violation. And, then give yourself the opportunity to bring yourself in compliant, because I don't want to speak for everyone, but I certainly feel that you're a PAC because of the express advocacy portion of your advertising. And
I think I was gonna say.
Yeah. so,
Okay. So that's an option as well.
Correct. That is correct. Yeah.
Okay.
My personal view is I'd prefer the discussion, because I think whether we find the violation, I think there's a possibility that the recommendation could be for good cause. And if we do a fine now with consideration later, retracting that, I guess it's not certainly doable, but more of an administrative challenge. I would personally advocate for what I discussed, because I think there's a potential for a good cause. And at this point, we don't know if good cause is, I mean, maybe the executive director has a view on that, but I think I'm personally challenged with coming up with a fine at this point.
So are you advocating for continuance rather than setting a hearing?
Yes.
And I will say, in the past, we have had circumstances where after setting, after giving the respondent an opportunity to have a matter reconsidered, we've then brought it back before the commission. And I would say mostly I won't recommend fines. But I've recommended good cause depending on the circumstances of the case. So at least as it relates to that, I would say we've done that before. We've reconsidered a matter and good cause depending on the circumstances of a particular case.
Fair enough.
I move for continuance of
Second.
this matter.
Oh, sorry.
Sure.
Yes, we have a
So-
question.
It's already done.
We're gonna accept Commissioner Lau's question.
Which is, are we gonna put an end date on this?
I would say, what's our September?
The 28th.
14th to the 28th.
14th and the 28th.
South to the 28th.
Yeah, I mean, either one of those. Okay, continue the matter to September 28th.
That's my amendment.
Okay,
Thank you, Mr.
That's
Long.
fine.
okay. So we have a motion to continue the matter to be brought back to the September 28th hearing.
Okay.
It's been duly seconded. All in favor, please signify by saying aye.
Aye.
Opposed, same sign. Motion carries with a vote of 7-0. This matter will be continued and you will come back before us, September 28th. Okay, thank you so much. Thank you everyone for appearing.
Madam Chair,
Um,
Madam Chair, I am excusing myself to go
Yes,
pick up.
I've been watching. Okay, thank you.
Absolutely.
Okay.
Easy stuff now, right?
Okay.
Easy stuff. Oh, I'm sorry. Okay. Yeah, I'm sorry. I'm sorry. I'm sorry. No, I'm sorry.
Yeah.
Thank you.
Knows how to use it.
Actually, I probably don't use
I
it.
forgot spoken rule,
Okay.
you shouldn't be talking like that.
Need some lessons.
That's right.
Okay, so are we gonna do these things first?
Yep. Let's
Okay.
do these and then we
Okay.
can figure out where we want to go from there.
Mr. Caraway's comment, we're gonna do then.
Easy stuff.
Okay,
No one around for this.
okay, so the next group on the agenda is group recommendations. The first one is no violation. That is case number 2023R-214. Mr. Richter.
Yeah, this is one where the board referred him for filing late. But when I went onto the website, look, he did. I don't know where the confusion starts. The board never really got back to me. I chatted with them briefly yesterday. But there is a reflection in the records that the report was filed on January 31st, which would make it timely. So I'm recommending that there's a violation.
So moved.
Second.
All right, we have a motion that's been duly seconded. All in favor signify by saying aye.
Aye.
Aye. Motion carries with a vote of 7-0. Next group is the Good Cause Group. These are cases number, all beginning with 2023R. So we have 2023R-207, 209, 220, 231, and 234. Mr. Richter.
Most of these, actually, on a number of them, the report was only filed 1 day late. But they were referred, so a response was submitted, the report was filed. Obviously, my recommendation is to find violation for good cause. A couple I'd like to point out would be 2023 R-231, where there was a 2020 prior, but the explanation that was submitted by the treasurer, new treasurer, a lady by the name of Brittany Irwin, was that, the former treasurer left the position in January or February. I don't think it was January. She was not appointed until after the due date for the filing of the report. And she didn't know anything about it until she got information from the commission that the annual report was not timely filed. And so she, and so taking that into consideration, I just feel like a good cause finding is appropriate for that particular case. And then 2023 R-209 is also a good cause where there's prior and with the health issues that were identified in the response and candidates father passing away, et cetera. I felt like good cause was an appropriate recommendation in that case as well. So I'll be glad to answer other questions that the commission may have.
Questions, Mr. Richter? Hearing none, do we have a motion?
Second.
Okay, we have a motion on the floor. It's been duly seconded. All in favor signify by saying aye.
Aye.
Pose same sign. Motion carries with a vote of 7-0. The next category is the $50 fine category. These are all going to begin with 2022 or 2023 R, excuse me. Well, yeah. 2023 R -210, 211, 215, 217, 219, 222, 223, 225, 226, 227, 233, and 236. Mr. Richter.
Madam Chair, members of the commission, in these cases, all the reports were filed, but they were beyond the 10 days, the 2-week period around the due date for filing. Responses were submitted to the commission that gave reasonable explanations, but due primarily to the late filing dates of the respective reports. My recommendation is to find violation and impose a fine of $50. I'll be glad to answer any questions that the commission may have.
Any questions or comments?
I'll move the recommendation of the executive director.
Second.
Okay, we have a motion that's been duly seconded. All in favor signify by saying aye.
Aye.
Post same sign. Motion carries with a vote of 7-0. The next case is to consolidate these cases, find a violation and impose a fine of $50. Those cases are 2, 023R 205 and 2023R 206. Mr. Richter.
Yeah, and at various times, we will take two cases like this that are submitted by a county and put them into the same referral. We did not in this particular case. So they were established as separate cases, but they involved the same committee, the same treasurer. The reports were filed. They were filed beyond a 10-day to 2-week period. A response was submitted. The candidate, I have the candidate, that's an incorrect statement. The treasurer is new to making campaign finance filings, and so I'm taking that into consideration. That's the primary basis for my recommendation that we consolidate these cases, find a violation, and impose a fine of $50.
Any questions? Hearing none, do we have a motion?
So moved. Second.
All right, we have a motion on the floor that's been duly seconded.
Keep going.
All in favor signify by saying aye.
Aye.
Opposed, same sign. Motion carries with a vote of 7-0. All right, the next is $100 fine. That case is 2023R 212. Mr. Richter.
Yeah, sorry about the listing on there reflects $50 fine. That should have been $100 fine. This is a situation where there is a prior, the filing, the reports were filed, a response was submitted. To me, it didn't go beyond to make a special finding for this campaign committee to go to a less defined amount. So I believe my recommendation is to find a violation, impose a fine of $100. I can't speak. Sorry.
So moved.
Second.
All right, we have a motion on the floor. It's been duly seconded. All in favor signify by saying aye.
Aye.
Opposed, same sign. Motion carries with a vote of 7-0. The next case is a $25 a day fine with reconsideration option. That is case number 2023R 228.
The reports have not yet been filed. No response was submitted to the commission. So my recommendation is to find a violation, impose a per diem fine, but give them the opportunity to have the matter reconsidered as appropriate.
So move the recommendation of the executive director.
I'll second.
Right, we have a motion on the floor that's been duly seconded. All in favor signify by saying aye. Opposed, same sign. Motion carries with a vote of 7-0. The next case, it's $17,000 fine plus $100 a day with reconsideration option. That is case number 2023R 221.
This particular candidate campaign committee have multiple violations. This is the next step in the line. And so my recommendation is to find a violation and impose a fine of $17,100 plus $100 per day, $100 per day until the reports are filed, to give them the opportunity to have the matter reconsidered if they file the reports.
Questions? Hearing none, do we have a motion?
So moved.
Second.
All right, we have a motion that's been duly seconded. All in favor, please signify by saying aye.
Aye.
Opposed, same sign. Motion carries with a vote of 7-0. The next case would be a motion to consolidate this case 2023R 218 with case number 2022R 579. Find a violation and impose a fine of $17,000 plus $100 a day with reconsideration option.
Obviously, you see there's a pending matter before the commission that has not been previously resolved. So I'm recommending that we consolidate those matters, find a violation, and then impose a fine of $17,000 plus $100 per day, and give the respondent the opportunity to have the matter reconsidered if they file their reports and request reconsideration with the commission.
Questions?
I'll move the recommendation of the executive director.
Second.
We have a motion on the floor that's been duly seconded. All in favor signify by saying aye.
Aye.
Post same sign. Motion carries with a vote of 7-0. The next cases will be continued for service. I'm going to read those into the minutes. 2023R 204, 2023R 208. They will all start with 2023R dash 213, 216, 224, 229, 230, 232, and 235. Those all have been continued. So at this time,
Yeah.
Okay.
I would assume so, yeah.
This time it's kind of a natural break before we start the next case. So it's 12 o'clock. 11:59, so let's go into recess for how long? Yummy.
Five minutes.
Half an hour? Okay, so we will come back into session at 12:30, so. All right, so we're in recess at this point.
Didn't you see that coming?
Are you there? You're going.
Right.
Isn't that to be technically more caffeine or is it just?
I think Diet Coke does. It should. I thought Mountain Dew had more.
Because if you live by that. code,
Thanks a lot
you're
for
not deviating.
and ruining mine. Okay. It is 12:34. I'd like to call this meeting back into session. The next case on the agenda is case number 2021 G-005 Hicks versus Schmidt. So,
Correct, Madam Chair. This is a continuation of the matter that was started on May 4th. And we continued it to today. It was coming to a conclusion. No, you're fine. It's just me with all the various papers. Preliminarily today, before we take some testimony, because I'm hoping to get some testimony, there are a couple of motions pending for the commission to consider. One would be a motion from Mr. Hicks, who is challenging the order that I circulated, granting Mr. O'Brien's motion to eliminate, and granting the motion to quash that was submitted on behalf of Brian Katz. We should take that motion up first. We could take up the motion of Mr. O'Brien before that, if you wanted to do so, where he was moving to dismiss the case based on certain contact that Mr. Hicks has had with the chair and vice chair. We could take that second, or we could go ahead and deal with that. My recommendation on that particular issue would be to deny the motion because the statutory preclusions are really pertinent to the commission members. I appreciate Mr. O'Brien wanting to make that motion. If we ever get to a point where we're challenging the decision of the commission, I guess that could be an element of an appeal. But I don't believe that, I don't believe it's appropriate to contact the commission members based on the provisions that are in the statute. I think the preclusions are more on the commission members than they are concerning sufficient to dismiss a case. I've delayed it on for a while. However, you, Madam Chair, and the members would like to proceed, we can proceed.
Madam Chair, can I just make a comment on that motion to dismiss and the contact made with the chair and vice chair of this commission? Neither one of us responded or entertained any interaction with the complainant.
I would agree with that.
Can I make a comment or?
I don't think at this point. So we should take the motion to. I don't have that in front of me, I apologize.
Which one?
The motion to dismiss based on contact.
Right there.
Okay.
That's what I was just.
Okay. So what action do I need to propose on that?
Well, my recommendation is to deny the motion to dismiss.
So commission,
So moved.
Second.
okay, we have a motion that's been duly, a motion on the floor that's been duly seconded, all in favor of this motion, signify by saying aye.
Aye.
Opposed, same sign. Motion carries with a vote of 7-0. So we've taken care of the motion to dismiss.
Thank you. Then the other motion, oh, sorry, that's okay. I'll find it here in a second. Too many papers. Essentially, the next motion is Mr. Hicks' motion to overturn, or for the commission to overturn my order on the motion to eliminate and the motion to quash That's the other issue. That's the other motion they had, we need to take. Mr. Hicks is the move and could certainly have additional opportunity to briefly address it. Mr. O'Brien is here. He could address as well, as could Mr. Kelly, Philip Kelly, who is with the Office of the Attorney General, who represents Brian Katz from the Secretary of State's office.
To address that.
Sit down and stand there.
And then, yeah, we'll have you
Over there.
now. Now stand up here and we'll have you sworn in.
Wait, we're gonna test you, the proceeding, or the truth, the whole truth, and not the pictures out with that?
I do. There's two things I want to address with this. You can read all the stuff that's been submitted around it. But the first one, I have the ability to give them out. These are copies of two previous orders of the Ohio Election Commission that took place back in the Freeman case. And in one of them took place during the discovery period and was signed by Mr. Richter. And one of them took place during the hearing period and was signed by, at the time, Commissioner Beatty. Okay, and it was something that was heard.
Yes.
It was something that was heard before the whole commission. But in the order that was done where Mr. Richter signed off on it, he actually gives a description in the order as to what his authority is to issue an order. And this is, and I saw Kurt Hartman do it, say, Chris, can you have these? But these are the two orders I'm drafting, using it as an example. This is one point. This is basically saying the order itself is improper in the first place. Because the executive director or the state attorney does not have the authority to give an order outside the discovery period. The other orders outside the discovery period have to be from the commission itself, not from the executive director. So once he handles that, I'll point to the section that I think is pertinent, where Mr. Richter described his own authority. So the one that is dated, oh, do you want to give that? I sent you copies, so. The one that's dated July 21st, 2021. Third paragraph, this is the one that was issued during the discovery period. And Mr. Richter describes his authority here. Ohio Administrative Code 3517-109B, same authority, he cites the order that he issued. Allows the staff attorney to do all acts of furtherance of the interest, purposes, and procedures on behalf of the commission through the discovery process. This order is intended to clarify which issues are pending before the commission that has arisen during discovery. And the authority that was cited by the executive director to have the order in the first place is part of the Ohio Administrative Code relating to its authority in the discovery process. So that's point one, is I don't think the order was proper. Whether the order is right or wrong, I'm just making the point that outside of the discovery process, the orders, he does not have the authority to issue an order. And orders need to be processed by the commission, which if you look at the other, doesn't have a date at the top, but the other order that says, order of the Ohio Election Commission says June 25th in the first line. This is an order that was during the hearing period, and you'll see it was considered by the whole commission, and the vice chair, who was acting as the chair for purposes of this, signed off on the order. So that's my point, is that the order was improper in the first place. In the second place, let me hit two things. First is the Mr. Katz testimony. So Mr. Katz, Gene Schmidt, not me, testified.
I'm sorry.
Gene Schmidt testified in the last hearing on the I think it was 4th of May, repeatedly to multiple conversations he had had with Brian Katz relating to the reporting of subject expenses to this that are involved, that got tied up with this inquiry. So she repeatedly referenced multiple conversations. And then I could point to the specific exhibits, But the two notes that have been provided, one by originally Mrs. Schmidt, her husband, in the note talks about discussions. Okay, the one provided by Katz says, we don't give advice, but it says, as I told you in our discussion. So the notion that his testimony is not relevant, or that what was actually discussed is not relevant and can't be subject to cross-examination. She's put forward the assertion that she did it properly because Brian Katz on multiple occasions this with her. How to report this. I don't know what that all entails, but that was her assertion, not mine. I didn't make that assertion, she did. And now I'm simply asking to be able to cross-examine Brian Katz on what exactly is true or not true. I mean, he could come up, he could be testifying and say, I never had any conversations with any of them. Okay, or I had a conversation where I said, I won't talk to you and hung up the phone. But the representation made by Mrs. Schmidt, not me, both in email and testimony, is that she had these offline conversations, not one, but multiple, with Brian Katz. And specifically on how to report this. So for example, and I'm glad to play back, I got set up here, I could play it back from the last meeting. She said, I had prior conversations with Mr. Katz on how to do this long before my husband sent this email. Prior. One of the things the Secretary of State will not do, are very cautious about doing, is putting anything in writing. That was her words. I'm glad to play back the testimony from I have the video here of that testimony. They basically tell you everything over the phone and you have to copy it down. We put this in writing to document the fact that we really have been trying to pay this debt and trying to do it correctly and consistently with the law. So she's making a representation that I got advice from Brian Katz offline that's not documented through multiple discussions, not just the one that her husband refers to. And I asked merely, well, then I would like to ask Brian Katz about these discussions. She also made the assertion that the discussions that they were done without documentation, specifically to not have documentation. So the notion, first off, I go to the first thing, the order of the executive director was not supported by, in the first place, he can only do orders like that during the discovery period, not during a hearing. But the second thing, the notion that Brian Katz is not a relevant witness, that I deserve the right to cross-examine, is crazy. She's made the assertion that she talked, I mean, I feel like I'm being an obvious horse. The respondent is the one who made the assertion that she had multiple offline conversations that are undocumented with Brian Katz relating to her campaign finance reporting. And why is this important? I'll tell you why it's so important. Because at the heart of my complaint is that there were compensated professional services that were received in kind that were not reported. She's already also made the insinuation that this David Goldstein invoice, if you remember this, try to your brain cells, you know, remember this David Goldstein invoice, somehow it might have been plussed up for some of this. It might have been this, it might have been that. So how it was described, how it was the discussion around it, what was this invoice? Because I don't believe it was plussed up. I think that might become a convenient attempted excuse. Is that, well, we didn't report this, but maybe this invoice was plussed up for it. And that's why we didn't report it otherwise. And to my point, I'm very transparent where I'm going and what I'm thinking and why I think something's important. The notion that I'm not allowed to discuss it with Brian, bring Brian Katz in, is the height to me of just crazy. He clearly is relevant. So I brought up point one. The executive director or staff attorney, as it is in your, exceeded his authority in the order in the first place. It's not a valid order. Part two, Brian Katz is absolutely a relevant witness by any standard of rules of evidence for being able to question him when the respondent is the one who has claimed to have discussions with him about her campaign finance reporting that are not documented anywhere. And even all of the email evidence provided of it, both emails refer to discussions that took place at some point in time. And then the third thing on the motion about Mrs. Schmidt's last issues with in my view of reporting compensated professional services. You know, I provided in my thing, I think 4 or 5 different of the rules of evidence that this relates to. So, you can't come in and just say, here say, he's a bad guy. But this is past practice, habit, should have known better, should have known, these are all rules of evidence things. Of why certain areas are subject to questioning. I'm not asking her about her care of her dog. Did you ever abuse your dog, or did you do this or do that? It's particularly pertinent because under, and I, as I said, I'm not going to rattle through it here, but I cited a bunch of rules of evidence. In the director's order, if you guys think about the director's order, I don't even know what to make of it. It never cites any rules of evidence. It never cites one rule of evidence. And then it says that the prior testimony, his request was effectively that all the prior testimony be stricken and this is not legit. That was his motions, and that was granted. But then in the order from the executive director, it says that will be considered by the board members. Well, if you grant his motion, then that means you're not supposed to consider it. So it's very confusing to me is that the motion itself, I don't have it in front of me, so I'm just going from memory. You know, you can look at it and it refers to, you know, the testimony that took place so far, you know, that'll be considered by the commission. Well, if the motion is granted, then you're not supposed to consider it. And I think it's highly relevant. I think it also now has, if you remember where we left this, was that there was supposedly a legal agreement that prohibited Ms. Schmidt from discussing her prior issue with not reporting professional services that were given in kind of her campaign. Illegal, and that was where we left that last meeting. You know, we're supposedly going to have a get together or something and talk about, you know, what was this legal agreement? Was it legit? Was it not? And now this is the way just to evade that whole question, because I think there's another question now that has arisen because of that prior testimony is, was it a lie? Is there actually any legal agreement? Okay, by the way, one of the other reasons why evidence is admissible to ask questions is because the actual FEC documents on that prior event are public records, and that's something you can question people on. You know, I've given like 5 different rules of evidence that apply to them. And I think a very compelling case. So let me edit out. You've probably read the stuff, hopefully you've read the stuff, you know, and paid close attention to it. But first off, the order was outside the authority of the executive director in the first place. Second off, the notion that Brian Katz is not a witness that could be asked about conversations that she brought up. I never brought him up. It's her exhibit that brought up that doesn't make any sense whatsoever. That doesn't make any sense whatsoever. And I've provided a ton of rules of evidence, and I'm a little confused by an order that says I'm granting a motion that says you should not strike all this stuff. But on the other hand, in the motion that says the commissioners will consider it. You know, it doesn't make any sense. So that's my supposition, my discussion / presentation to all this. I think that I think the order should be ruled. If you're asking me, don't really ask me, but if you ask me what you should do, it's that order is not valid. There needs to be some structure here. That the section on orders, his own words say that authority is during the discovery process, not during the hearing process. So the order is invalid. I think that Mr. Katz is an absolutely relevant witness. You know, given I'm just responding to her representations in this. And I think that the questioning on prior cases of her not reporting in-kind compensated professional services by like 5 different rules of evidence are all valid. So I don't see the order as being legitimate. And I hope this commission will reverse that order, and that we can make sure that we can have, you know, I'm not asking like, hey, decide that I'm right and she's wrong. I'm just asking that we have a fair process. That's all I'm asking, is that we have a fair process and not some orders that are outside the authority of the executive director that do things like not allow cross-examination of somebody who's been put forward by her as a basis for why what she did was okay. And not let people walk from what could have been a false statement made under oath about a supposed legal agreement relating to what can be talked about and what can't. So thank you guys very much.
Thank you. All right, thank you so much. I appreciate it.
Thank you, Madam Chairman, members of the commission. In the first instance, this problem can be solved very easily if the commission members want more. Would make a motion to adopt as a commission's order, Mr. Richter's order that he issued without regard to whether he had authority to issue in the first place. It was very reasonable, rational. Mr. Richter's been here 25, 30 years that I recollect, and he knows what he's doing. He assessed the legality of it, at least as to the authority of Mr. Katz. I'll leave it to the Attorney General, but I think the only thing I would say is merely because Ms. Schmidt said that she talked to Mr. Katz doesn't entitle him to subpoena him as a witness. And I would also say that if she didn't file a report and report the disputed debt with constant content that the lawyer was trying to collect and was here going to tell you, or I had told you, is I didn't report it because Brian Katz told me I didn't have to, then I might side with Mr. Hicks here, but she reported it. It was a disputed debt. She reported it as a disputed debt on her prior report. She then contacted the Attorney General, and as the email reflects, Attorney General said, we can't give legal advice, talk to your lawyer. And her husband, who's her treasurer, said, well, we just want to do what's right here. And they did do what was right. They filed a report. They listed the original invoice for $39,000, the disputed invoice they paid. And at least in my view, it wasn't something that could be justified by the person submitting it, but nevertheless, to negotiate it out, it was paid. That $20,260 was reported on the report. And not only that, the treasurer went back 3 reports and amended reports to reflect, okay, I didn't know about this before. I have found about it. I disputed it. I negotiated. I paid it. And on the next report reflected that, but then went back to 3 reports. So, I think that first we can solve the no authority problem by the commission adopting Mr. Richter's order. Secondly, on Mr. Katz, I believe that what he has to say is not relevant because it was reported, and we're certainly not saying that he told her she didn't have to. And then the motion in limine, I filed that because and I believe that it memorialized how the chair had ruled on my objections. And you'll remember, I don't want to sit here and object to every question Mr. Hicks asked that's improper, because that would extend the hearing longer than needed to be. And so I put a continuing objection to all questions in a certain area. And that was granted by the chair, and Mr. Hicks ignored it. He continued to ask something about some Turkish embassy deal, something that happened 20 years ago, this legal settlement that occurred. And I would correct the record, there was no finding that she failed to report improper in-kind contributions. There were allegations and lawsuits about it. And that's why she's saying they were settled. And as a result of the settlement, I was advised I shouldn't be talking about it in the future because the people might come back and file another lawsuit, because settlements like that typically have an NDA or non-disclosure agreement. So I think she had a legitimate concern there. And I merely wanted to have an order issued today so we don't spend the rest of today and for the next 3 meetings this commission has talking about things that have nothing to do with this case. As Mr. Richter said in his proposed order, I'll call it, for the commission to adopt, those don't have anything to do with the primary, post-primary, or subsequent Goldstein collecting for constant content issue. That they happened 20 years ago. They don't have anything to do with this case. And so let's deal with only relevant issues. So with that, I have nothing further. Thank you.
Thank you.
Unless there are questions.
Thank you, Madam Chairman, and members of this commission. My name's Phil Kelly. I'm here on behalf of Mr. Katz. I just want to point to two, maybe 3 issues with Mr. Hicks' motion. First and foremost, Mr. Richter did act within his authority in properly quashing the subpoena. Mr. Hicks points to a provision in the administrative code that essentially grants a staff attorney power to do all acts in furtherance of discovery matters. But this neglects another provision within the administrative code, which allows the staff attorney to quash overly burdensome subpoenas. This is a completely separate provision from the discovery matter that Mr. Hicks is referring to. This provision, if I can specifically enumerate it, is 3517-1-11 subsection B3A. This specifically allows Mr. Richter to issue orders pertaining to subpoena matters. Secondly, Realtor's motion is very untimely and honestly should not be considered by this commission today. Provisions of the administrative code requires that motion be filed within 7 days, business days prior to the date set for the hearing. And Realtor's motion was filed on Monday, July 17th, approximately 3 days ago. Realtor's motion is also improper under the administrative code because it is essentially requesting that this commission reconsider Mr. Richter's findings on the subpoena issue. The administrative code specifically says no party adversely affected by a finding. The commission may request reconsideration of that finding unless there's a specific provision. There's no specific provision that I have seen. And lastly, as to the merits of the subpoena duces tecum asked for testimony about all documents and communications in printed form. Mr. Hicks is now discussing conversations that allegedly happened outside verbal conversations. This is completely outside of the subpoena's request. The subpoena request testimony about communications in printed form. Verbal conversations are outside the subpoena, and so any purported conversations that happen are irrelevant to this matter. And as you can see in the exhibits provided in the motion to quash, Mr. Katz informed Schmidt that the office cannot provide legal advice about the extent of the communications. Again, any verbal conversations are outside of the subpoena. Thank you.
Mr. Hicks.
Just to correct a few things. The section that he just mentioned. Well, first off, an order is not a finding. So a finding is like you had a violation, that's a finding. An order or a motion is not a finding. Secondly, 35171-11 says a party may file, by the way, I printed out a reference pack of authenticated copies of the actual OAC and so forth on the issues that might come up today. So if you guys want to have them, I have copies. It says a party may file request issuance of subpoena and subpoenas do as take them and shall do so in a timely manner. All subpoenas shall be issued by the staff attorney to the commission unless a timely motion to squash is filed with the commission. If in the reasonable, if you read that section, okay, what it is that when I notified on the 5th, the day after our last hearing, him of the subpoenas I wanted to have issued. Okay, I'm sorry, the executive director and respondents council of the subpoenas that I wish to have issued. That was time for the respondent to question the issuance. The actual section that he cited as subpoenas is referring to prior to the issuance of a subpoena. Prior to the issuance of a subpoena. Once a subpoena is issued, and those of you that were on the commission before, I only know the commission from when I've been coming to meetings, all motions to quash subpoenas that had already been issued by the executive director were heard before the commission. And I could go for orders on that also, okay? So he had, Mr. O'Brien had, because I think I could pull them up, but I think the subpoenas were issued on about the 25th or 26th of May. So he had 3 weeks to object to a subpoena that I wish to have issued. The executive director issued the subpoena. That takes this off the table. This is about, it does not, this refers to before the issuance of a subpoena. Once a subpoena has been issued and somebody has a motion to quash, it's like, as those of you who were on the commission before, I know a lot of new faces, but those motions to quash always have been heard before the commission, not by just some order. Okay, so there's a set of things, and I can pull up and provide my request was for just a subpoena for Brian Cass. And then there was a do it take part to bring any correspondence you've had with these people. I could pull it, I started trying to pull it up to look at it. This notion that it said like, I only asked for him to testify on the documents he was gonna bring, it's completely false. And no other, I think there were only 2 of 8 subpoenas I asked any do his take part to bring something with you, Mr. Goldstein and Mr. Katz. And all the other ones, I never said what I was gonna question them on, just I want a witness subpoena issued to this person. So this notion that I somehow, first off, I don't issue the subpoenas, Mr. Richter does. I make the request and the commission issues the subpoenas. And I could pull up to see what the face of the subpoena said, but this is kind of a red herring, the notion that the subpoena was, meant I only wanted to talk about documents he was gonna bring with him. Would be contrary to the email I sent requesting subpoenas. And I haven't pulled it up, but I'm guessing it's probably contrary to the face of the subpoena itself. As to what actually happened. So I think that's why I printed out all these authenticated rules and stuff, because today I'm like, we gotta stick to some rules here. And not make stuff up or create innuendo about the rules. And like I said, I don't know if you guys say this, but I welcome, anytime a rule gets brought up, I 100% welcome that we look at the rule and what does the rule actually say. So I don't think anything about, what's been said. And by the way, last thing I want to say, Mr. O'Brien just entered a bunch of testimony about the prior event involving Ms. Schmidt, that there was no finding of violation. There was no this, there was no that. I would object. I would say that most of what he said was not correct. Okay, but these are the little slippery tricks. Okay, so he tried to put testimony in that this was not a real thing. It didn't happen. It was 20 years ago. I think it got finally adjudicated in 2016 or something. So that's not 20 years ago. Okay, so this is not good. And the point is, it's a relevant area of questioning. And you can't have a situation where then he can enter testimony. And if we go back to the actual hearing, I don't think there was an objection ruled upon. The questioning continued. And then eventually we said, we're going to stop till we figure out whether there's an order, a agreement somewhere that says that she can't talk about this anymore. There was never a ruling. And I want to point out too, is in prior hearings with respect to the chair, one of the parts of the hearings was designating an attorney separate from the chair to rule on objections. You remember Mr. Norman, performed that function in the past. And I think that would be good decorum to have here, to have an attorney that's separate from the chair that actually rules on objections, and that we get actual rulings on the record as to whether an objection was, Mr. Norman did a good job of when objections came up, they were either sustained or overruled consistently and clearly. And I don't know, I could go search on the video transcript of the last meeting. I don't know the words, sustained or overruled were used that often when it came to objections that were levied. So I just wanted to clean up some of the stuff that was just said in terms of what the truth is, in terms of what the rules actually say in this, and I stand by all of my prior comments.
Thank you. Sure, Brian, do you have anything in response to the?
I recollect the chair did tell Mr. Hicks more than once that we'll move on, that after I objected, I don't know because I don't have the transcript or the recording right here in front of me, but it was clear to me that Mr. Hicks was being told to move on, and he ignored that direction from the chair. Whether you use the word objection sustained, I can't affirmatively say, but it's clear to me that he was being told to move on. And in fact, we ended the hearing, as you recollect, by him saying, I refuse to move on. And so that's the only thing I would say.
Thank you.
Yeah, well, what would you like to address? I don't recall the specifics of what was going on, but I do know that there were various objections that were approved, and certainly we came to a conclusion at the end where Ms. Schmidt, was indicating she wasn't going to answer as it related to that set of circumstances, and we stopped consideration at that time. I don't know if there was anything more specific that was stated, as I recall, concerning those particular circumstances. Sorry, I don't have more to add to that.
How we will handle objections during this meeting.
Oh, as it relates to going forward, as you and I have had a conversation where I will generally move or act on, objections as they are submitted to us, and go forward from there.
So that's how we'll conduct this meeting when in regards to objections. As Mr. Richter obviously is our staff attorney and is the attorney representing us on the board, so.
What is the order going to be followed that he issued or adopted or ignored, or how are we proceeding?
I'm
We
sorry.
haven't gone on that yet.
Oh, okay.
No decision has been made there.
Okay, well, I thought that's what the chair was
No.
addressing.
No, just objections as they.
As they go forward on other issues.
Exactly.
Okay,
Within
thank you.
this hearing, if an objection comes up, we will handle it and Mr. Richter will handle those objections. So as far as the motion in front of us, do any commissioners have questions on what we've heard and what we've read? Ms. Richter, will you tell us again what your recommendation on this motion?
Well, certainly I issued the order. I believe I have authority. I believe I have authority to do so. And my efforts in that regard are primarily because I just want to see the matter move forward. And my belief is that it may not have been wonderfully worded. I will certainly admit to that. But I don't believe, with all due respect to the arguments presented this morning, and I've read the materials that were submitted prior to issuing the order, that as it relates to the issues that we have pending before us in terms of, the propriety or impropriety of in-kind contributions, and the nature of the expenditure that was made to Mr. Goldstein on behalf of Constant Content, I didn't see that Mr. Katz's testimony would elucidate anything of value as it related to that aspect of the case. So that's why I granted the motion quash. And as it related to the motion in limine, I think, we spent almost 3 hours, as I recall, maybe even more than that, hearing testimony from Ms. Schmidt. I think Mr. Hicks did a reasonable job of presenting the circumstances surrounding Ms. Schmidt's history of what went on there. And then in the motion that he submitted in opposition to Mr. O'Brien's motion in limine, there was an outline of the circumstances that involved what he was trying to get testimony as it related to. I shared that with all of you, so you have that available to you. You could read that and see what the essence of that was. Going further into that, I didn't believe was beneficial for the commission in terms of. I didn't believe it was beneficial for the commission to go over that all over again and just slow down the process of trying to get to evidence on the issues that we're looking at today in terms of the in-kind contributions and whether there could have been something listed there, or the payment to Mr. Goldstein. And I'm merely trying to get us moving and get us to a point where we can get good, valid information as it relates to those particular issues. I'll be glad to answer any questions if the commission has other questions.
Any questions of commissioners at this point?
The current motion before us is dismissal, is that?
No, we decided that motion. The motion pending before us is whether it concerns my order, the order that I issued. And essentially whether the commission wants to reconsider that and make a different decision. Or I guess you could say allow it to stand. One of the ways, the way Mr. O'Brien addressed it in terms of endorsing it. Or if the commission decides it wants to go in a different direction, certainly, and overrule that and go their own way, that's certainly within the realm of possibility. It's your commission members' determination and choice as to how you proceed.
Mr. Hicks had, in the last line said the updated order should be withdrawn and both motions should be heard before the full commission and denied. That's what's before us, so. So the motion is for full commission review of the undated order of the executive director. Is the motion.
So I have a question. So we have two motions, one to eliminate, one to quash, right? Correct?
Those are the two motions on
Combining.
which I submitted the order on. I combined the
So
two.
you combine, okay, so we don't have to do it separately.
Right.
I don't believe so, no.
If you stand. Question is whether you allow the motion to stand or recommend a different path.
Right.
It'll work.
Nominate the freshman member of the committee that.
I will move that we deny the motion for reconsideration.
We have a motion on the floor.
Second.
We have a motion on the floor that's been duly seconded. All in favor signify by saying aye.
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 Post same sign. Motion carries with a vote of 7-0. So at this time, we will go into the actual presentation of the case. So,
And I will add just, do we know who's actually here physically close?
Witnesses?
Yeah,
Well, I think Ms. Schmidt was being examined by Mr. Hicks, and I
okay.
gathered that that would continue until he was done with her. There are three
You want me to
witnesses.
call them?
Mr.
That's what I'm getting to. Mr. Hicks, where do you plan on proceeding from here, Mr. Hicks?
Mr. Schmidt, and then there's potentially 4 witnesses that.
No, I understand. I mean, I presume Mr. Caraway is probably outside because he left the commission here, but the other 3 persons are, I guess, in their office down below.
Yeah, but
And so,
I
I
think
mean-
I still have, and because some of these things are some reasonable questioning for Ms. Schmidt, and then we can